Hello, my name is Takia Jones, and I am serving as a juror on the case of Charlotte Robinson versus Ashford Hospital. Ashford Hospital is represented by Aaron Correll. Charlotte Robinson advised Ashford Hospital released her personal protected health information to her supervisor the day before her surgery. Plaintiff Charlotte is suing Ashford Hospital because they released said information without her proper authorization. Ashford Hospital violated HIPAA because there was no written consent to release this information to the supervisor. Effective April 14, 2001, there was a mandate for HIPAA stating as such: there are national standards for the protection of health information. There are three entities: health plan, healthcare clearinghouse, healthcare providers who conduct healthcare transactions for patients. By a staff member sending the schedule electronically to Charlotte's supervisor, her privacy was violated. Not only did the email contain the schedule, it also contained Charlotte's demographics, her address, her social security number, former surgeries, birth date, age and/or payment information, her medications, primary care physician information, her personal psychiatrist information, and other health professionals who she has sought treatment throughout the last year. Because her supervisor was not on the OR team or the treatment team, the information shouldn't have been released to the supervisor. Charlotte's privacy was clearly violated. The hospital and staff members should be held responsible for this act. The defense advised that the patient should not have been allowed to sue Ashford Hospital. Instead, they suggest filing a complaint to the Office of Civil Rights of DHHS. They feel DHHS should determine if there was a violation and if a fine should be assessed based on the nature of the complaint. These fines range depending on the severity and the intent. The defendant claims that there has not been any evidence that caused harm, shame, or injury to the patient. A confidentiality agreement is signed by all staff members. However, Charlotte's supervisor was issued information unnecessarily. She didn't process her claims, nor was she on the operating team. Charlotte should be allowed privacy because there is no evidence that her supervisor needed access to said information. Direct supervisors do not necessarily have access to their staff members' demographics and other unnecessary information. This information is usually housed with the Human Resources Department. According to HIPAA, a patient can seek and obtain medical treatment while their information is being protected. As per Charlotte, her supervisor can have the ability to use any of that information that she was privy to as per Charlotte, her supervisor can have the ability to use any of the information against her possible advancement in the future. Poor ethical judgment was used in this case. Policies should be changed. The staff member should be held responsible. The hospital has not placed the employee on any leave, and they have not been reprimanded. This leaves the instance to possibly happen again. Without the employee and/or the hospital willing to accept any fault in this case, I am forced to find Ashford Hospital guilty. They need to review how the supervisor came privy to this information. This information was deemed confidential. They also need to research the way so that this does not happen in the future. Was the staff member who sent the email properly trained? When there are new updates regarding privacy, are there additional training provided for the hospital staff? There is no written consent from Charlotte to release any of this information to her supervisor. There's no reason her supervisor should have there's no reason why her supervisor should have been issued this information. There's no written consent. According to the Electronic Communication Act of 1986, There is a violation when electronic communication or email is given without consent. This is proven to have been done in this case. Privacy refers to an individual's expectation to keep control of his or her space, as well as knowledge of certain private information. A nurse, staff member, or healthcare provider has a duty to provide privacy to those that they treat. The right is guaranteed by the Health Insurance Portability and Accountability Act. Patients have the legal right to control access to their private information. Once the institution or person is entrusted to this private information, it is the duty of confidentiality to restrict the disclosure of that information without permission that is strictly defined and given on as necessarily needed. After hearing both sides, I again find Ashford Hospital guilty. They failed to protect the privacy of Charlotte Robinson's personal health information and records. Thank you.